Mr. Mark, if I might, just tell me about the 22nd Amendment. What does it provide?
The 22nd Amendment, Senator, my career has mostly been in criminal prosecution. I haven't had an opportunity to use that one specifically.
Anyone able to help on the 22nd Amendment to the United States Constitution?
Well, Senator, I believe it is the amendment that deals with a two-term limitation on
Correct.
the service of
It
the
states
president.
no person shall be elected to the office of the president more than twice. Mr. Mark, is President Trump eligible to run for president again in 2028?
Senator, without considering all the facts and looking at everything, depending on what the situation is, this to me strikes as more of a hypothetical of something that could be.
It's not a
raised.
hypothetical. Has President Trump been elected president twice?
President Trump has been certified the President of the United States 2 times.
Is he eligible to run for a third term under our Constitution?
I would have to review the
All I need to
actual
tell
wording
you
of
is
it.
the language of the constitutional amendment that makes it clear that no, he is not eligible to run for a third term. Anybody else brave enough to say that the Constitution of the United States prevents President Trump from seeking a third term? Anybody willing to apply the Constitution by its plain language in the 22nd Amendment? Nobody. All right, let's move on. Mr. Coons, what is res judicata? How does it apply?
It's a judicial doctrine that prevents a judgment that has been, in one case, applies to a, you can't go into court after a final judgment in one case and have it, and litigate the same things again.
How is that distinct from collateral estoppel, which precludes litigating the same things?
Res judicata, one involves the same party, the other involves the same things.
And what's a requirement for these two doctrines to apply?
Notice, opportunity to be heard, final judgment of a court of competent jurisdiction.
Anyone disagree? If I might, Mr. Coons, is it pronounced the same way mine is?
Yes, it is.
Coons?
Yes, Senator.
My family's name was spelled that way when we came to the country. So, you were one of 3 judges on the panel in Alexander v. Trump, where the president was suing the Pulitzer Prize Board for defamation. When did your work on that case begin? When were you assigned this case to decide?
I first learned of that case in approximately January of 2025.
Not when the briefs had been filed?
No, Senator. The way it works in our court is we are not assigned cases when the briefs are filed. Once the case is ready for disposition, the clerk randomly assigns it to the judges in the court.
And when did you first speak to Senator Scott's office about your interest in a district court seat in the Southern District of Florida?
I mean, I've had many conversations with Senator Scott's office. The one about an interest in the Southern District of Florida, I believe, was in November of 2024. I don't know the date, but it's in my Senate Judiciary questionnaire.
And when did you release the opinion ruling in President Trump's favor in this matter?
So I learned of the case in January of 2025, and the opinion was released in, I believe it was February 12th, 2025.
That's correct. So you issued an opinion where one of the litigants before you was the president and in favor of the president while you were in active conversation with the senator's office about seeking a federal judicial appointment. Is that correct?
For a position I did not, in fact, get, Senator.
How did you end up in front of me today?
It's a different position, Senator.
Did you consider recusing yourself from that particular decision?
No, and the canons that govern us in Florida, Senator, as I believe this committee has previously heard, it did not call for me to recuse myself. I did not have an interest in the litigation, and none of the basis called for recusal, and the Florida Supreme Court instructs us, the appellate judges, that we are not to recuse unless one of the bases in Canon 3 exists.
Does the Florida canons not require you to recuse if one of the parties before you has an interest that could be reasonably concluded by any common citizen to cloud your judgment on that matter?
Senator, I disagree with that characterization. I had not heard from the White House until after the opinion was final. I had only spoken.
When did you interview with the White House counsel's office?
At the end of February of 2025. I don't know the date, but I believe it's in my Senate Judiciary questionnaire.
Thank you for your testimony on that matter. Mr. Hendershot, if you would just take a minute and talk me through again how collateral estoppel and res judicata are different from each other.
Senator, I'm not sure I can improve much on Judge Coons. I think that often res judicata today is used as sort of a catch-all term, but generally I think the difference is between claims and claims that may have not been brought but could have been brought potentially.
Right.
Collateral estoppel, and res judicata is more of a thing actually decided, as the Latin would suggest.
Thank you. Do you agree that judges should not be influenced by external pressure to rule in any particular way?
Yes, Senator, I do.
President Trump stated March of this year at a public event, quote, "We have rogue judges that are criminals. They're criminals, what they do to our country, the decisions they hand down and hurt our country. Is it possible for a judge's decision to be correct as a matter of fact and law, even if it differs from the president's desired outcome?"
Senator, I want to tread carefully because of Canon 5 in terms of commenting on political matters, but in the abstract, yes, decisions can be correct, and any citizen can criticize what a judge has done. That is, I think, part of their right to speak.
One of the most revealing moments of this judicial nominations hearing wasn't a complicated legal debate. It wasn't an obscure constitutional doctrine or a controversial court ruling. It was a simple question with a straightforward answer. Senator Chris Coons asked the nominees about the 22nd Amendment, the constitutional provision that limits a president to being elected no more than twice. Then he followed up with an even simpler question. Is Donald Trump eligible to run for a third term in 2028? What happened next was striking. Instead of immediately citing the plain language of the Constitution, several nominees hesitated. Some characterized the question as hypothetical. Others declined to provide a direct answer. One nominee acknowledged that Trump has been elected president twice, yet still stopped short of explicitly stating what the amendment clearly says. That hesitation became the central moment of the hearing. Coons wasn't asking for a political opinion. He wasn't asking whether a third term would be popular or desirable. He was asking whether the Constitution permits it. The amendment's language is public, direct, and widely understood. Yet the room suddenly became uncomfortable. The exchange raises an important question for Americans watching these hearings. What should we expect from judicial nominees when they're confronted with basic constitutional questions? Judges are entrusted with interpreting the law fairly and independently. When nominees appear reluctant to state what many view as a straightforward constitutional limitation, critics argue it creates concern about whether political considerations are influencing legal analysis. The hearing didn't stop there. Coons also pressed one nominee about a ruling involving Donald Trump, while the nominee was simultaneously pursuing a federal judicial appointment. The questioning focused on judicial ethics, impartiality, and whether recusal should have been considered. While the nominee defended his actions and cited judicial canons, the exchange underscored the intense scrutiny that accompanies lifetime appointments to the federal bench. Perhaps the most significant takeaway came later when Coons shifted the discussion to judicial independence. He referenced public criticism of judges and asked whether a judicial decision can still be legally correct, even when it conflicts with the president's preferred outcome. That question cuts to the heart of America's constitutional system. Courts are not designed to serve presidents. They're not designed to serve political parties. They're designed to serve the law. Whether the issue is presidential power, constitutional limits, or controversial rulings, the public expects judges to apply the law consistently, regardless of who benefits politically. This hearing became a reminder that the confirmation process isn't just about qualifications. It's about understanding how future judges view the Constitution, judicial independence, and their responsibility to uphold the rule of law when political pressure is at its highest. If you believe public officials and judicial nominees should be held accountable for every answer, or every refusal to answer, hit like, subscribe to the Hearing Breakdown, and turn on notifications. We break down the biggest hearing moments, the toughest questions, and the exchanges everyone will be talking about long after the gavel falls.